Settlement negotiations are generally not admissible in a court of law. However, they are admissible in the court of public opinion. In this video, I'll tell you why attorneys need to be cognizant of this fact whenever they are talking settlement. Hi everyone, my name is Wayne Pollack. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion. In this video, settlement negotiations and the court of public opinion. There's no FRE 408 or its local equivalent in the court of public opinion. Media-savvy litigants in high-profile legal disputes may wish to publicly disclose the substance of settlement negotiations in those disputes in order to try to gain leverage in those negotiations, or to try and cause reputational harm and damage to an adversary and or the adversary's legal team. Attorneys need to be cognizant of this fact whenever they are engaged in settlement negotiations. They need to be thinking about whether the words they are using in written communications and or the words they're saying in oral communications are the kinds of things they'd be okay with if those words were quoted in a daily or national newspaper article about that dispute, or in an article that's posted on a prominent online media outlet. The concern attorneys need to have about how their settlement negotiations could be perceived by the public is that, depending on how the public perceives those negotiations, that could cause reputational harm and business harm both to the client and the attorney and or his or her law firm. If the public perceives the client as being a bully or arguing or negotiating in bad faith or somehow acting immorally, that could cause reputational harm and business harm to the clients, and the client could lose significant clients, customers, and the overall trust of the public if they're perceived to be negotiating in a way that's viewed as, again, immoral or bullying or generally unfavorable. But for attorneys and their law firms, there also is some reputational and business risk here. If the attorney comes across as being a bully, and again, acting in bad faith or seemingly acting immoral, that could cause serious problems for the attorney and his or her law firm. Remember, the key audiences of law firms are all human beings who could generate a negative impression of a lawyer in a law firm based on what they read in the media. I'm talking about current and prospective clients, current and prospective referral sources, current and prospective lateral partners, lateral associates, employees, and the like. These people could view an attorney's efforts to resolve a case as indicative of a problem, or they could view it as generally unfavorable to the attorney. And I like to say that when people have a negative impression of a business or a person, that negative impression speaks softly, but it carries a big stick. All it takes is for one rainmaker attorney to not join a law firm because they got a bad impression of the law firm through public reports about a high-profile case, or for a client to not go forward with engaging a law firm because of that same report, in order for that reputational damage to translate into serious business harm. And this is not just some academic thought. This happens in real life. Recently, in Pennsylvania, the chair of the Pennsylvania Republican Party had to resign, or I should say chose to resign, soon after the Philadelphia Inquirer published an article that disclosed or discussed the sexually explicit messages this male chair engaged in or exchanged with a female who was running for Philadelphia City Council. There was also what the newspaper called an explicit photo that was sent from the male to the female. And in the Inquirer's reporting of the story, in the story that caused the resignation of the chair, there was a few paragraphs about settlement efforts, and the woman was telling her story and talked about the way the attorney for the chairperson came to her, talked to her, negotiated with her, and suggested that if she didn't sign a non-disclosure agreement, that her reputation would be damaged by this whole process. I don't think that that note and that story made that attorney or that law firm look particularly good. And nothing negative may come out of that story for that attorney and for that law firm. But man, in today's day and age, with the pushback against non-disclosure agreements, especially when it comes to relationships or interactions between men and women, that's somewhat explosive. You can imagine a female general counsel or a male general counsel or a male or female would-be lateral partner reading that article and saying, whoa, this firm is the kind of firm to use non-disclosure agreements still? I'm not a big fan of that. I'm taking my business elsewhere. The substance of settlement negotiations is admissible in the court of public opinion. Attorneys need to be mindful of that fact and make sure that they are not saying anything or conducting negotiations in a manner which could come back to haunt their client, themselves, or their law firms. There's no hiding behind FRE 408 or its local equivalent when it comes to settlement discussions in the court of public opinion.